Good afternoon, everyone. My colleague John and I are going to discuss how the increasing use of AI purchasing agents may challenge traditional principles of trademark law and how trademark practitioners can help manage potential risks. Trademark law relies on the assumption that a human consumer will view and interact with trademarks when making purchasing decisions. The similarities of the marks, both visual and phonetic, the similarities of the goods and services, the channels of trade, sophistication of buyers, and actual confusion are all based on human behavior. When an AI purchasing agent and not a human makes the purchase decision, it may reshape how likelihood of confusion is determined. AI purchasing agents are tools that can help a consumer find and purchase products with minimal or zero human input, other than that initial prompt. We are all likely familiar with one or more of these tools: Amazon's Alexa, Apple's Siri, Google's Assistant, and Microsoft's Copilot Checkout.
The scale of this market is significant. It is estimated that over 101 million Americans have smart speakers in their home that are being increasingly used by consumers to initiate purchases of goods. 60% of online consumers in the US regularly buy products using smart home voice assistants. 74% of consumers using voice-based artificial intelligence have completed some part of the retail buying process with a conversational voice assistant. Projections indicate conversational commerce will be worth $1 trillion by 2028. So this is not a niche issue. It is one that trademark practitioners and businesses need to be thinking about now. As AI increasingly replaces humans at the point of purchase, it may raise novel legal questions about whether the current standard for determining likelihood of confusion applies to this new technology. For example, can an AI purchasing agent be considered a consumer under trademark law? Can we apply existing likelihood of confusion standards in scenarios where AI autonomously makes purchasing decisions? Who could be held liable for the AI purchasing agent's initial mistake in purchasing the wrong product? And could evidence of this mistake serve as evidence of actual confusion? These questions have not yet been addressed and answered by the courts in the US.
So let's work through a hypothetical to illustrate these issues. A human consumer verbally prompts an AI purchasing agent to purchase Alpha, ALPHA brand soap. AI, acting as the consumer's proxy, searches for and purchases the requested item for delivery to the consumer. The consumer had no input or approval for the sale after the initial prompt. When the soap arrives, the consumer notices that it is Alpha ALFA brand soap, which is not what they intended to order. They can see the different brand because the ALFA logo looks quite different from the Alpha mark. If the consumer had initiated the purchase themselves, online or in person, they would have purchased the intended product. The consumer may now either initiate a return or simply keep and use the soap, taking a potential sale away from the Alpha ALPHA mark.
So here's the key issue. The AI purchasing agent could not see the visual differences in the logos, color, and designs like a human would. It may have been a purchasing decision based solely on oral interpretation of the consumer's verbal prompt. If this happens often enough, Alpha PHA soap sales could be impacted, and consumers who are not familiar enough with Alpha's logo and branding may not even notice that they have received the wrong product. If Alpha's product, FA, is subpar, this could also harm the goodwill Alpha PHA has built into their mark. So how does the current likelihood of confusion standard apply here? The marks are phonetically identical and visually similar. The products are identical. The channels of trade are identical. Therefore, a likelihood of confusion is likely to exist under this current standard. But does the sale initiated by an AI agent constitute actual infringement? The consumer was not confused when making the initial prompt. Alpha, PHA, may argue that post-sale confusion and harm to goodwill, and US courts have recognized post-sale confusion, but the unique circumstances surrounding AI have not yet been addressed. On the question of whether AI can be a consumer, trademark law assumes the average consumer has an imperfect recollection of the goods and services, rooted in human perception. AI is not limited by those constructs and may have a perfect memory. Courts haven't addressed this yet, but possible findings may include AI is not a consumer and cannot be confused like humans. AI is acting as a proxy for the consumer, and the human's original intent should be determinative. Or AI may be placed into an entirely new category, an intelligent consumer, which could significantly reshape likelihood of confusion standards. In our hypothetical, the AI agent is arguably acting as a proxy. The consumer's original intent to purchase PHA soap was not fulfilled.
On the question of liability, the obvious target is the competitor, using the confusingly similar mark. Still unresolved is whether the AI platform itself could be held liable. And there may be additional concerns surrounding the algorithms that highlight a competitor's brand when a verbal prompt mentions another brand specifically. As for actual confusion, it is typically very strong evidence in an infringement claim. Post-sale confusion may be helpful, but using it means acknowledging that the AI selection of a competing product demonstrates the marks were similar enough to cause an error. This arguably places the AI purchasing agent in the position of the consumer. And in this voice-driven environment, phonetic similarities will likely carry more weight than visual ones.
So what does that mean in practice? For trademark clearance and monitoring, how AI trademarks act as source identifiers is evolving, and AI purchasing agents are an emerging risk factor that should be addressed early on when adopting a mark. When clearing marks for clients in industries increasingly linked to AI purchasing agents, phonetic similarity should become a key factor. Marks that rely solely on unique spelling or visual elements for source identification may face confusing risks when goods are frequently purchased through verbal AI prompts. Brand owners with phonetically similar marks that may have previously coexisted without issue may now face new challenges. On liability and evidence of infringement, in addition to claims against the junior user of a similar mark, there is an open question on whether AI agent itself can be held liable, particularly if there is an agreement in place that promotes competitor products, or if a competitor's product is highlighted in response to a verbal prompt for a specific brand. Although courts have not yet had an opportunity to opine on these issues, evidence should be collected of an AI purchasing process from the verbal prompt to product delivery and post-sale confusion. Numerous instances of post-sale confusion could demonstrate actual confusion, as well as a loss of goodwill and sales for the senior trademark owner.
So the current likelihood of confusion standards may not be fully equipped to handle the unique concerns surrounding the use of AI purchasing agents. The entire framework assumes that purchasing decisions are made by humans. Courts will be forced to either adopt the existing tests to AI, rely on the perception of the human who made the initial prompt, or develop an entirely new standard. The intersection of AI and trademark law is still very much unsettled territory, and the trademark practitioners and businesses can start building these considerations into how they select, manage, and protect trademarks now, before the courts are forced to answer these questions for us. Thank you for your time, and we're happy to take any questions.